Limp Bizkit frontman Fred Durst has just filed a shocking $200 million lawsuit against Universal Music Group.
He had not received any money from the band Exploitations ever. I wonder what Universal is going to say because it cannot hide. This isn't a lawsuit. This is a wake-up call to the entire music industry. Welcome back. I'm top music attorney, Miss Krystle. I've been lawyering, litigating, I run a law firm, and I've done this for the last 10 years. So I was in the process of reviewing the complaints that Fred Durst and Limp Bizkit filed against one of the biggest record labels in the world, Universal, and I saw that Rockfeed, love this YouTube channel, released a video kind of covering this and really nicely summarizing. So I figured, let me give you a lawyer's reaction to the Rockfeed video, and then I can incorporate what I've seen in the actual complaint. And then on top of all of that, give you my personal experience dealing with this exact issue with Universal. Let's go.
Breaking news into Rockfeed, Limp Bizkit frontman Fred Durst has just filed a shocking $200 million lawsuit against Universal Music Group, alleging that for decades now, the band hasn't received any royalties for their music.
Okay. Everyone just take a beat. The band has never received any royalties. It's one thing to be like, we didn't receive a lot of royalties, we didn't get paid enough. But no, they're saying they've never received dime one.
We've seen and heard in interviews that members of Slipknot have said they hadn't made any money off of their music. And as we know, so many artists are entirely reliant now on revenue from their live shows and their merch, and many people just discount the idea that bands would make money off of their music. But why is that? Is it because that music doesn't make any money? Well, no, that's not true. Limp Bizkit has currently 15 million monthly listeners.
And actually closer to 16. And this is just on Spotify. Obviously, for DSPs, digital service providers, there's more than Spotify. So the point just being that people are very interested in this band. And actually, as complained of in the complaints, let's just take a quick peek, as complained of in the complaint that was filed today in federal court. This is in the District of California. And we see Fred Durst, Limp Bizkit, and then Fred's label, which is Flawless Records, LLC, against Universal. And then they have the does, right? So the placeholders 1 through 20, because, likely they will amend to add additional defendants.
Jokes about Spotify not actually paying people. The truth is, they really do pay people. But the question is, who has been getting paid? And the answer in this case, according to Limp Bizkit, is not them, which is egregious. Decades after they signed their record label, we're expected to believe that they're still recouping their original deal that they signed. But Universal Music...
And recouping, if we're saying recouping, all right, typically when you sign with record labels, major, even independents, if you get a signing bonus, if the label pays for your marketing and your studio time, typically the lawyers put this into the contract and they say, this is all going to be defined as an advance. Advances get recouped before you get paid any royalties. It's just how these deals are done, right? We're like the bank. As the record label, we're the bank. And so we're going to get paid back first. So the allegation here, and what Universal is saying, is that the band is still in an unrecouped position, which is why they haven't received any royalties. Are we buying that?
Apparently feels that they're not entitled to any money. So it's going to be interesting to see how this case plays out. But rest assured, how to tell if somebody's real in the music industry? Are they willing to file a lawsuit against the biggest label on the planet? And that's exactly what Fred Durst has just done. So he's not just sticking up for himself. He's not just sticking up for his bandmates, but he's also sticking up for the numerous other artists that have either encountered this in the past or will encounter this in the future.
Okay, and then just for clarification, let's look at the complaint, but my understanding is that Fred Durst signed his label as an imprint under Universal, Interscope, and so the artists that are represented as part of this additional deal are having the same problems. Now, could this case ultimately help additional artists who are signed with Universal? Yes. UMG, Universal Music, one of the biggest record companies in the world, hold itself out as a pro-artist company that fights for the rights of artists and, quote, provides the most creative and commercial opportunities possible. As set forth herein, plaintiffs have discovered, contrary to these claims, not only did UMG never have any intention of paying plaintiffs, it designed and implemented royalty software and systems that were deliberately designed to conceal artists, including plaintiffs, royalties, and keep those profits for itself. This is what is so interesting about this because, where we typically have the discussion is the music business is rigged, artists are never going to get paid back, record labels are lying about their expenses. These are common things that we hear. What Durst is claiming here is that actually Universal's, its entire payment processing is set up to ensure that artists don't receive their royalties. And he gets into how this works practically, which we'll cover here in just a sec. So here are just some of the main points. So on December 1st, 2000, Limp Bizkit and Interscope entered into a recording agreement related to the creation of music. So basically the complaint talks about how Limp Bizkit did a deal with Interscope, right, under Universal on December 1st, 2000. But before that, Limp Bizkit had signed a deal with Flip Records Incorporated, and this was in 1996. And so what the complaint goes on to say is basically the band did a deal and the band kept executing amendments, which is very common, right? So typically, if things are going well for the band, the record label and the band will agree to an extension, right? To more options, more albums, and in exchange, the band gets more money. And what I can show you guys is that on the third amendment, okay, the flip agreement between the band added additional monetary consideration in the amount of $7 million. Okay, so now the band is obviously doing really well and the label advances these monies, but again, those monies are going to be recouped. And typically it's from not just royalties, but it might be from shows, it might be from merchandise. And then also it does say that the band was getting paid. So for example, Universal had agreed to give the band annual payments ranging from $9,000 to $20,000 per year, split amongst all band members, which was also subject to certain deductions. And then here's the piece that we just talked about. So Durst is the 100% owner of his label Flawless Records, pursuant to Flawless Agreement, which was also with Interscope Records. Flawless Records became an imprint of Interscope. And so Durst was getting a deal of 50% of profits generated by the new artists that he brought to Interscope. Okay, so with that context, let's go back to the video.
Here's what we know. While he may have done it all for the nookie, that doesn't mean that he shouldn't be compensated for his work. In a shocking lawsuit filed today, Fred Durst alleges that Universal Music Group hasn't paid Limp Bizkit any royalties for decades. It's a stunning claim from a band that sold more than 50 million albums over the years, and to date, still has more than 15 million monthly listeners on Spotify. But where is that money going? Limp Bizkit's attorney says not to the band. In fact, he said the band had, quote, not seen a dime in royalties.
I mean, I've done this for a really long time. I'm a musician myself, and I can just tell you that it's just so shocking to me when really successful bands have just never received any royalties, and a lot of times never said anything about it, never asked, never engaged in a lawyer to send a letter and be like, hey, where are my royalties? And then we do see what happens, which is once Durst had retained new legal counsel, they went fishing. And when you have a good attorney, that's what the attorney does. They go, I wonder, let's see. And in the let's see, I think they discovered something like $1 million was just sitting in an account. But let's see.
Signs a record deal. In many cases, they're provided with an advance or a large lump sum payment. And over the years, as the band releases music, the label will recoup that money from the sales of their music. Now, that's an oversimplification, but you get the gist of it. And it's hard to imagine that decades later, with all the massive success that Limp Bizkit is having, that this label is somehow still recouping the advance from their music. In Fred's lawsuit, his attorneys contend that hundreds of other artists may have been treated the same. How can a major global corporation such as Universal Music Group have so many problems paying their artists what they rightfully earned? And in the digital age of streaming, where the numbers are automatically calculated, why are so many artists kept completely in the dark about how much money their music actually makes?
I can answer that. We're going to go to the complaint, but let me just give you my personal experience. The last time I had to deal with Universal for one of my clients. So this is a client who represents a legacy act. You would know this band. It's a very big band. And there are royalties being paid into this Universal account. And the client was so frustrated of just not understanding how to get the royalties, what was happening, to get the statements, that eventually our office was like, look, creative lawyering here. Let's just go ahead and we're going to go in. We're going to try to get this account set up if it needs to be set up. We're going to see what's going on with your royalties. And so we did the thing. So I'm poking around in this account. I got to tell you, it was so complicated to get this thing set up. It was so complicated to access the statements and understand what we were actually looking at. And so I can tell you from personal experience, I have no reason to doubt what is being claimed in this complaint. All right, so here we go. In or around April 2024, Durst retained new lawyers and explained that he had not received any money from the band Exploitations ever. Like, whoa, ever. Durst's lawyers were shocked because they were aware the band's phenomenal increase in popularity over the past several years. Not only that, Durst was informed by the prior owner of Flip Records that Flip Records was receiving millions of dollars in recent years on Limp Bizkit's assets, and that the amounts that Flip Records was getting from UMG had grown exponentially over the past few years as interest in the band was renewed. All right, so let's get to the juicy stuff. On or about April 9, 2024, plaintiff's business managers finally contacted Universal, stating they had not received any royalty statements from Universal. I think people wait too long to ask questions. I think it's something of a combination of I don't want to be perceived as difficult, or I'm scared to hire someone because you know what? They're going to charge me money. I don't know how much it's going to be. I don't know what's going to happen. And so people wait way too long. But then this is what happened for Durst. So he hires the attorney, and then I guess the business managers also are stepping in, contacting, getting into the Universal portal, and they noticed that the band's accounts had a balance of almost $700,000 and another band account that had a balance of $350,000. All right, so there's our million. When plaintiff's business managers inquired how to get these amounts immediately paid, Universal responded on May of 2024 that they needed to create a royalty vendor for Limp Bizkit and requested that they fill out various forms such as a W-9 and provide bank verification. Upon information and belief, Universal had never previously set up plaintiff as a payee because it had no intention of actually paying them. Indeed, according to Universal's royalty statements, plaintiff's accounts had been payable starting in 2019 and then fraudulently reclassified as unrecouped to prevent payment. The fact that Universal allegedly needed new information for people it had paid advances before is highly suspicious and suggests this was either a delay tactic or that something in Universal's system wrongfully shut plaintiffs down as payees. One of the reasons why my law firm is retained the most frequently is because we have complaints about no reporting, bad reporting, inaccurate reporting from record labels, which is an issue that I've dealt with before, which is, hey, label payment portal doesn't work, we can't get in, and so we have no idea what's going on with these royalties, and then you have to retain an attorney to help you get those answers.
In Fred's lawsuit, they allege it's all by design. Durst and Limp Bizkit accuse Universal Music Group of devising a systemic and fraudulent policy deliberately designed to conceal royalties from their artists and keep those profits for itself. It adds, UMG's creation of such a system, while holding itself out as a company that prides itself on investing in and protecting its artists, makes plaintiffs' discovery of UMG's scheme all the more appalling and unsettling. The attorneys mentioned the major resurgence Limp Bizkit has been having. They're going to be playing stadiums with Metallica next year. The attorneys write, despite this tremendous comeback, the band had still not been paid a single cent by UMG in any royalties until taking action against UMG, leading one to ask how on earth that could possibly be true.
To his point, he goes, the real ones, the serious ones, will be willing to file a lawsuit against the biggest record labels in the world. And then here's what happens. You know, you're going up against Goliath, but here's the thing. Goliath has to play by the rules, which means that there are discovery disclosures, there are discovery responses that have to be provided. And so we get, as the attorneys, right, representing the bands, representing the artists, we get to go in and look at the books. Because the whole basis of the claim is that you did not pay our client properly, your accounting is inaccurate, and so the label is required to produce that information. And so that is one of the benefits of when you do need to actually file a lawsuit. Procedurally, discovery allows you to get a lot of information that otherwise the record labels typically will not give you.
The situation began to unfold back in April when Durst retained new representation, and they were shocked when he told them he had not received any money for any Limp Bizkit exploitations ever. This is where things somehow get even crazier. So after all these years, Fred's wondering, hey, why am I not getting any money? So as any reasonable person would, he tries to go and get a statement. Hey, what's the balance here? Let me see the numbers. Where are we at? How are we doing? And extraordinarily, according to this suit, UMG declines his request simply to get some sort of an accounting on where the band is at in terms of their recoupment. The lawyer's right.
100%. Half of the time, it's just about getting a response, because here's what these labels do strategically. Sometimes if we jump in, lawyer, letterhead, scary legal arguments, we get the record label to cough up the information. But they know that most people are not going to actually sue. And so sometimes just ignoring a demand letter is the strategy. But if you didn't have something to hide, you would produce the accounting, right?
Durst explained that he had been informed by UMG that he had not received any royalty statements because UMG told him over the years that it was not required to provide them since his account was still so far from recoupment.
All right, I would love to see the contract. I would love to see the contract. Maybe this is in there. And this is where I go to the whole, if you have a universal agreement that's 80 pages long, and then they have a sentence in there that says, if you are unrecouped, we don't have to account to you. It's strategically built in to safeguard the label when later on, Limp Bizkit comes back and says, hey, you haven't sent me any statements. So whether this language is actually in that contract or not, I really hope not. And I just always go back to, I really hope they had an attorney when they signed this agreement. I really hope that some of these things would have been caught. Because I would have had a field day if there was language that said that the label did not have to account if the clients allegedly had unrecouped advances. But here's the thing, if you do need to get a lawyer after the fact, you get a lawyer who can claim that certain terms are unconscionable, right? They should have not been in the contract to begin with. All right, anyway, I don't know if this language is in the contract. I'm just shocked.
Durst's representatives, suspicious that UMG was wrongfully claiming plaintiffs' accounts were unrecouped, suggested investigating further. It was at this point that Limp Bizkit's new representatives took matters into their own hands. They reached out to UMG, and they got a different response. Apparently now, Limp Bizkit actually had over $1 million in royalties, but the label had failed to alert the band about the money. This, of course, led to more suspicion.
Yeah, and so as we saw from the complaint, the facts alleged was that Durst's management, business management, went in, got the account set up, taking a peek around and seeing, oh, there are these amounts that have never been released because allegedly there are steps that have not been taken by the band, right, to give the applicable forms. And so this is where, is it reasonable? Is it reasonable to have all these different steps required in order to set up an account? Do you need to provide a W-9? Probably. And so will the label come back and be like, no, we have everyone do this. But equally, what Durst and the band are claiming is that this is a intentional tactic because a lot of artists won't do it. They won't know what to do. They won't know how to file these things. So therefore, these things won't happen, and the monies will just be maintained by Universal. So what happens to the money that just sits there forever?
You have running their accounting over there at UMG, if this is true. The Hamburglar? How do you go from, well, actually you're unrecouped to now, oh, well, you've got more than $1 million in your account. I mean, that's a big difference.
Yep.
So this naturally led to some significant questions about their accounting practices. 100%. Upon further investigation, the representatives didn't like what they found. Apparently, there were significant gaps in royalty statements throughout Limp Bizkit's history, including during the height of their fame in the late 90s and early 2000s. The lawyers wrote, UMG's failure to issue royalty statements, in particular from 1997 to 2004, the height of the band's fame, and during periods in which they made record-breaking sales with respect to its most popular albums, suggests that UMG was intentionally concealing the true amount of sales, and therefore royalties, due and owing to Limp Bizkit, in order to unfairly keep those profits for itself.
And then at least as it relates to the complaint says even if an account was in recoupment, Universal was still required to account to plaintiffs during those periods. So that answers the question as far as at least what plaintiff is saying, right? And this is how it typically goes with major labels, in that they do provide ongoing statements, even if the account is unrecouped, because there's just a transparency thing, right? If you're telling me that the account is $300,000 in the red, in the negative, we get to know that information. UMG statements to plaintiff that Universal was not required to provide plaintiffs with statements because the account was so unrecouped, were material misstatements indeed. This is belied by the fact that Universal, it's so funny, the attorney I'm against in one of my cases uses this word all the time. This is belied by the fact that Universal did in fact prepare many accounting statements during periods in which the accounts were in recoupment. For those of you who follow On Top Music Attorney, you know I just went to New Jersey for depositions in one of our litigation cases. I do this stuff all the time. So I know the gamesmanship that happens with major labels. And I gotta be honest, I wonder what Universal is gonna say, because it cannot hide. It now has a lawsuit that it has to answer to.
The suit also deemed the assertion that Limp Bizkit was somehow still unrecouped on their record deal after selling tens of millions of albums was highly suspect. They wrote, given that Limp Bizkit's first 3 albums had already sold several million copies by the early 2000s, the recording funds and costs should have been quickly recouped, and UMG should have started paying royalties on those albums right away, not over 20 years later. Later in the suit, they wrote, given the vast amounts of money collected by UMG in relation to sales of Limp Bizkit's and Flawless Records albums over the years, UMG is liable to plaintiffs for tens of millions of dollars in copyright infringement, if not more. Indeed, plaintiffs allege that the amounts owed to them by UMG following the recession of these agreements will easily surpass $200 million.
And then the complaint gets into some spaghetti accounting, as we'll call it. So specifically, there were statements that show there was $176,000 in a positive balance. Universal then overdrafted the account by almost $400,000 to the account for the band, and thereby generated the allegedly unrecouped balance of $186,000. But where did this additional $199,000 charged to the account come from?
So this is a very important lawsuit that's going to have major ramifications on potentially numerous other artists. This idea that an artist could potentially go to their label and ask for a financial statement and be told that they're under no obligation to receive that, if that is indeed true, is insane to me, especially in the digital age when the numbers are very clear.
Well, let me interject. Sorry to cut you off. So basically what happens is that in the label deal, what a lot of people miss is that it says, we're going to give you regular accounting reports. And that might be quarterly, that might be semi-annually. It doesn't specify what has to be in the accounting statement. That's why you need to have someone who looks at these details of the contract before you sign it. Because I know what that means. And I go, well, look, here it says you are not going to provide an itemized statement of your expenses, the gross amount that was earned, the amount that allegedly is unrecouped, meaning I want details. And so sometimes, to clarify, not sometimes, most of the time, these deals just say that the label is going to give you some kind of accounting statement, but it usually does not have very many details. So when we pop in and we go, hey, we need a detailed accounting of everything that has been paid for and accrued, that's outstanding, that's, reimbursable, and all of a sudden the record label's like, we don't have to give that to you pursuant to the contract. And sometimes they're right.
He's not just sticking up for Limp Bizkit and himself, but this is also for numerous other artists out there who could be impacted by these type of wacky situations where they're like, oh, we don't know how much we owe you. It's like you're a massive corporation who seemingly is making billions and billions of dollars, tens of billions of dollars, and you have no idea how much this band that made a lot of money for you is actually owed. And so
they know.
The lawyers bring up some really good points here where they say, hey, this should have been recouped a long time ago. How are you claiming that Limp Bizkit is somehow unrecouped? And for all of us out there who have spent money on Limp Bizkit music and to know that even all these years later, it's one thing to be an unrecouped band and to have a major advance, but we all know Limp Bizkit has made crazy money over the years, and to find out that it hasn't gone to Limp Bizkit is super frustrating if this lawsuit is indeed true.
Yeah, but look, let's devil's advocate for a second. We saw in the complaints there's been a bunch of amendments, and this happens. And I can tell you, this happens where the artist is like, I want more money. And so then the label pays a cool little additional $2 million and then another $7 million. And so this is a long-term relationship where there are sometimes tens of millions of dollars paid to the artist. Okay, and then that does need to be recouped. And then I guess the question is, are we saying that Limp Bizkit hasn't made $7 million, $10 million ever as of today? And then also side question, for those of you who are fans of Limp Bizkit, what is your favorite song, or better yet, what's your favorite memory? Drop your answer down below in the comments. Music Attorney is your #1 legal resource for artists, producers, and record labels. Get contract templates, one-on-one legal advice, free master classes, and everything you need for your music business. Go to topmusicattorney.com.
So we're going to have to look and see how this all shakes out. It could take many years, and of course it could also end up in a settlement. Maybe UMG comes out of all this and goes, hey, you're right, we messed up. We're going to pay you and we're going to make this right. And that would be wonderful as well if that ends up in that way as well. What it comes down to is Limp Bizkit had this amazing creative vision. They made this great music that people still love to this day, and they should be compensated for that. And Fred is willing to stand up to arguably the biggest company in the music industry.
There's more details in this complaint. So on July 15, 2024, counsel for plaintiffs sent a letter to Universal alleging that Universal had grossly underpaid plaintiffs with respect to their royalties, had failed to provide accurate royalty statements for all periods in which there were sales of any albums, and apparently had seemed to design a royalty system that systematically prevented artists from being paid their royalties. On about July 15, 2024, plaintiff's manager had a telephone conversation with Universal's SVP of Business Affairs. During this phone call, the VP claims that the non-payment of plaintiff's royalties, as alleged in the letter, was a one-off mistake due to an error with Universal's new software. He was apologetic over what was considered an egregious and embarrassing alleged mistake. However, when questioned about how an allegedly one-off mistake could happen to two completely separate accounts, so we had the band account and then we had the one for Flawless Records, the VP was not able to offer any logical explanation. That's not good. All right, and then on the 26th of July, 2024, Universal's agent, Scott Bauman, responded to plaintiff's letter claiming that it had paid the band approximately $43 million in recoupable advances over the years. Okay, there it is. That's what I was looking for. What is Universal claiming? Because they would have to claim, we have paid you $43 million. That's why we are unrecouped. Now, here's the thing. It's that they paid the bands, because usually all the stuff is included. We've paid for your marketing. We paid $5 million over all these different album releases. We put you on tour. We paid for the merch. And so sometimes that's how they stack up the numbers if they really have paid these expenses, right? But at least the complaint alleges that the band had been paid directly $43 million in recoupable advances over the years. With respect to Flawless Records, Universal claimed that the account remained unrecouped for many years, but stated that the account is now recouped and has a positive balance of approximately $2.3 million. Universal then directed Flawless Records to fill out forms, oh boy, via Universal's portal and or help desk in order to route payments to Flawless Records. Again, Universal did not provide any backup for this alleged amount and did not provide plaintiffs with any of the missing accounting records. Okay, I mean, so from what I can see, Durst, the band, I mean, they tried in good faith, and when they did get additional information, what they're saying is the information was nonsensical, and this one-off mistake didn't quite make sense to them. So now, what are plaintiffs asking for as part of this complaint? The first is for rescission. Okay, so they're saying that they want to have the agreements undone under the law, and so that they can get ownership of their music back. Now, what do you think about this? If there's been non-payment or underpayment, right, you have the ability to sue, you have the ability to go and get your money, but does that mean that the record label should lose ownership of the music? Drop a comment down below. Second cause of action, breach of contract. You breached the agreement by not paying us, and then certainly not paying us in accordance with the agreement. Now, what I did see is that the original agreement that the band had, they were getting 50% of royalties, which, For those of you who are kind of familiar with the music business, 50% is pretty good. You might get like 12% up to 18% when you're dealing with major labels. Third cause, breach of the implied covenant of good faith. Well, it's usually good faith and fair dealing, but good standing and fair dealing, which basically says that if someone has an obligation to act fairly under a contract and not do stuff to prevent the other person from receiving the benefit of the contract, I don't know, like logging into the account so you can get paid, so you can see royalty statements, then it's a bad faith, right? It's a breach of the covenant of good faith and fair dealing. And actually, in one of my cases, what the other side did related to accounting, spaghetti accounting, underpayments, all this stuff, I'm going to be claiming punitive damages, where I go, Your Honor, these are not only the baseline damages, but I want punitive damages. I want extra damages because of just how bad this thing is that the defendants did. More breaches of contract, breaches of good faith and fair dealing, and then we get to number 8. This is for breach of fiduciary duty. So fiduciary duty is typically when you have a party who is exercising control over your money, okay, like an agent. So in California, managers do not have a fiduciary duty to the artists that they represent, but agents do. And it's because agents actually receive and control money received on behalf of their clients. Count 9 for fraudulent concealment. You tried to hide it. The 10th cause of action is for intentional misrepresentation, right? You intentionally tried to hide this. 11th count is negligent misrepresentation. Man, they're going in. This is the kitchen sink here. 12th, promissory fraud. Defendants had no intention of actually performing on the promises of paying plaintiffs any royalties of profit shares at any time these promises were made. Count 13 for accounting. So basically you ask the court to provide accounting and full disclosure. Oh my gosh, look at they're still going. Count 14, and this is for copyright infringement. This is the one that I was really interested to look at. So let's see what they say. On September 30th, 2024, plaintiff serves defendants with a rescission notice, a copy of which is attached here too, incorporated by reference. The rescission notice rescinded the flip agreement, recording agreement, or flawless agreement. Plaintiffs, Limp Bizkit, and Durst are the creators of all of the musical compositions embodied on the master recordings, subject to the flip agreement, on information and belief. Oh, that's interesting. Okay. So this is what they're saying. Because here's the thing, guys. You can get statutory damages if there's a claim of copyright infringement. And this is how you can stack up how much you say that someone owes you very quickly. If you have the copyright registrations prior to the infringement. But what they're saying is that they're like, we hired the lawyers and gave you a notice saying that we are basically terminating the contract. And it's because you breached the contract, you didn't pay us, you've lied to us. And so they go, after receiving that notice, the label continued to distribute the music. Therefore, it's copyright infringement. And here's the language we always talk about. So there's liability pursuant to Section 504(c)(2) of the Copyright Act, and the sum up to $150,000 per infringement, right? So this is how we do 150,000 times all the times we can be like there was an infringement. Count 15, violation. All right, so now we're getting to the state law claims. So violation of the business code, and then asking for declaratory relief. So asking the court to say that there's been basically a termination of these agreements. All right, so this is the prayer for relief. This is what Limp Bizkit and Durst are asking the court to do. Wherefore, the general damages in the amount to be proven in trial, but exceeding at least $10 million. They want for an award of all profits, defendants, plus all losses of plaintiffs, plus any other monetary advantage gained by defendants. There it is. I told you. Punitive and exemplary damages, attorney's fees and costs, rescission of the agreements, a declaratory order stating that the band and Durst are the owners of all of the music, a restraining order to prevent defendants from doing more stuff. Okay, so just on that piece, what do you guys think? Are they going too far here? Right? Is it okay for them to be like, look, if you owe us money, you owe us money? Or is it fair to say, no, we want rescission of the contracts, we want our music back? This is an interesting one, okay? Because the amount of time that has to go in specifically for the discovery phase to figure out, and this is the sucky part to a degree, to figure out what's been going on with the label, right? And we're proceeding at this point to be like, no, there haven't been actual costs and advances, in excess of $40+ million, but you don't know. And that's the tough part. That's my frustration with labels when they don't just disclose things, because it's a little suspicious. if you say, hey, I just want to know the numbers, and then they don't come back and give you the numbers. And so now you have to sue to get the numbers. This is so interesting to me because I literally have dealt with Universal with this literal same issue on behalf of other clients. So I'll be following along, and if you need help in the meantime, you're always welcome to reach out to me through my law firm, Delgado Entertainment Law. But what I do recommend is that if you are early in your career, I always say go through my music business training first. It just gives you the contract templates that you need, the training on copyrights and trademarks, music marketing, music distribution. I mean, I cover everything, so you have everything covered. And then you get together with me and we can chat about your career from there. I'm Top Music Attorney. I'll see you on the next one.